Good evening. My name is Dan Churchwell, and I want to welcome you to SkepTech 2021, a growing clash between government, technology, and free speech, an online conversation facilitated by the McCandlish Phillips Journalism Institute at the King's College in New York City and sponsored by the Acton Institute, a think tank whose mission is to promote a free and virtuous society characterized by individual liberty and sustained by religious principles. I have the privilege of serving as the director of program outreach at Acton, and we're delighted that you have joined us this evening for the vigorous conversation to follow. You can learn more about our work at acton.org. Paul Glatter is an associate professor of journalism, media, and entrepreneurship at the King's College in New York, where he also directs the McCandlish Phillips Journalism Institute, and he will be introducing the format for tonight's event. Welcome, Paul.
Thanks, Dan. We're pleased to sponsor this event with the Acton Institute. At the McCandlish Phillips Journalism Institute at the King's College, we host events like this one. We also operate programs for students who study journalism for 4 years or for a semester as a visiting student at King's from one of our 41 partner schools, and also for high school students who come to our summer academy program in July. So please visit the King's College online or the McCandlish Phillips Journalism Institute website to learn more about those things. Some of our research interests at our institute include media ecology, First Amendment issues, technology ethics, and the startup economy. And so all of those topics align with our program this evening. And as it turns out, maybe some of these topics are verboten in some tech circles these days. In fact, we took out an advertisement on Twitter, Facebook, and LinkedIn to promote this event tonight, and found out after a couple of days that Twitter and Facebook rejected the ad saying this: your ad may have been rejected if it mentions politicians or sensitive social issues that could influence public opinion, ... or the outcome of an election or pending legislation. So this evening, I can assure you that we're not trying to affect the outcome of any elections here. We're aiming for quality discourse and insights to help citizens think about these important issues of 2021. If you want to ask a question tonight, you can do so using Google Voice Text, and the number it's in your chat box. It's also, I'll tell you now, it's 646-355-8946, and we will get your questions to the speakers. And as part one of our evening, we have a keynote address, and then part two is going to have a panel discussion. And so as our part one, we welcome the writer and attorney, David French. He is a senior editor at the Dispatch, where I hope many of you read his pieces. He's also a columnist at Time Magazine. He's written for many outlets, including the National Review, the New York Times, and the Washington Post, as well as many others. A few other facts that you may or may not know: he's a military veteran, a graduate of Harvard Law School, and he's practiced public interest law before focusing on writing. His most recent book, which I encourage you to buy, is titled "Divided We Fall: America's Secession Threat and How to Restore Our Nation." That book title is apt to our topics tonight, and we welcome you here, David.
Well, thanks so much for having me. I have to say that I am still not used to the whole notion of a keynote address when I'm just sitting in my chair Zooming, but that's what we're doing still for now. Hopefully next kind of keynote address I'll do will be actually in front of a live audience. Thanks so much for having me. I'm really excited about this conversation. We're wading into a topic that it's hard for me to remember an argument about a federal statute that has been more dominated by ignorance and sometimes outright dishonesty than the arguments surrounding Section 230 and free speech online. It's an argument where people just outright misstate the law. They outright misstate its purpose, and often in service of a partisan political agenda. But we're not here to curse the darkness. We're going to try to light a candle. And what I'm going to do is I'm going to walk through Section 230. I'm going to walk through the differing left-right proposals to the problems that to the controversies and contentions we have surrounding free speech online. And I'm going to talk about what I think is the real true issue and why it's going to be so hard to solve. Okay. So let's start. Let's start with a little bit of history. Let's go all the way back to the very early years of the internet. Let's go back to the years, two cases in 2 years, 1991 and 1995. 1991, I was a first year in law school. And in that time, nobody knew what an internet was. Like nobody really had any idea. There were sort of 3 ways to get online. You could get online through 3 services. One of them called CompuServe, one of them called Prodigy, and one of them called America Online. AOL still exists. I'm not sure if Prodigy and CompuServe exist in any form right now, but AOL still exists. I still have an AOL address that I got in, I believe, 1993. So I'm still clinging to that thing. But in the early days of the internet, there was a question about what do we do about this sort of new freewheeling speech environment. Comment boards, chat boards, these were something entirely new. We hadn't really seen them. Well, we'd seen things like comment boards where people would put flyers or free speech walls on campuses, but this whole online thing seemed really new. So in 1991, and one of the things that people were worried about is what do you do when somebody says something online that might be libelous, might be defamatory? So in 1991, there was a court case in New York. A federal court in New York dismissed a lawsuit against CompuServe on the grounds that CompuServe couldn't be held liable for user speech because when you were writing in a chat room or posting on a comment, they didn't exercise any control at all over the posted content. So whatever you wanted to put up on those in those chat rooms, you could put up. CompuServe just put it straight up. It was up there. So CompuServe was not going to be held liable. 1995, however, a New York State court ruled that Prodigy, which was in direct competition with CompuServe, could be held liable for user content, for a user comment because it moderated its message boards. It removed comments that violated Prodigy's posting guidelines. And so all of a sudden, here we are in the mid-90s in the early internet, and you're facing a challenge. You're facing a real issue that these emerging internet companies have, and it's sort of the all or nothing challenge. You either let everything on and you're not going to be liable for any of it, or you let some of it on and you could be liable for all of it. Both of them were, both the options, when you think them through, are essentially intolerable. If you're trying to run a corporation that's trying to reach a broad number of Americans, anything goes. You know, we all know what happens on message boards, on chat boards, on any place in the internet where anything goes turns into a sewer with remarkable speed. Any place that has no rules becomes a bad, toxic place fast. If you think about places like 4chan, Acton, if you talk about, well, we'll talk about some other social media options later. But where anything goes, it gets bad. It's not a place where families want to be. They often turn into places where not just families and kids don't want to be, but where decent people feel deterred from even looking at them. So anything goes was unacceptable. But if I'm liable for everything, if I'm liable for anything that you say by moderating it all, then that'll often mean that nothing goes. Why would I even have that kind of message board? Why would I expose myself to the opinions or the ideas or the factual assertions of people I don't know, that I don't edit, that I don't have any real control over? So anything goes typically would mean then nothing goes, because if anything goes is intolerable, and some things go is impossible because I can't possibly protect myself from all the potential liability, then rather than anything goes, it's going to be maybe nothing. And what was interesting about that anything goes versus nothing goes, or responsible for nothing if anything goes and everything if just some things go. One thing about that was really an odd way of formulating the issue, because that's not the way things work in the offline world. In the offline world, we're very familiar with things like content moderation. Let's take, if for those of you who are in a college classroom, a professor might say, here's what we're going to do, guys. Let's say you're taking a class on the Civil War and you're at the class time where you're talking about the Battle of Gettysburg. The professor can say, we're going to have a conversation about the Battle of Gettysburg, and I don't want any personal insults hurled at anybody. I want it to be civil and respectful. So you've done content moderation right there. That's content moderation. You have a topic it's going to be about, and you have rules that are set around the topic. Does anyone then think that whatever is said in the conversation is then somehow also the professor's speech? No, of course not. It's still the speech of the students. And if the professor enforces his content moderation, that doesn't mean that therefore the professor is speaking every time a student opens his or her mouth. Or look at it this way. If you have a public gathering, like if you're fans of Parks and Rec, you know, these Parks and Rec town councils that were hilarious on the sitcom, and you have a public gathering and you say, here are our rules. You're going to speak for 3 minutes. You may not engage in personal attacks. You may not engage in, racial slurs or racial epithets. And we're limit the topic to the subject of pending legislation. You've content moderated, but that doesn't mean that every person who gets up at the town council meeting is speaking for the town. They're still speaking for themselves. So this was a really odd kind of conundrum that these early courts were putting these internet service providers in. So the solution, this is some of you guys may really not recognize this at all, but there was a time in American history where Congress could act, where Congress would pass laws. I know it's hard to believe, but it occurred. And in 1996, rather than going through years and years and years and years of litigation to sort of carve out under the First Amendment, where did, what were the limits of the ability to regulate internet communications, et cetera, Congress just cut right to the chase. It passed Section 230. And it did two things. One, here's the famous publisher platform sort of language, although I'm just going to read it to you so that I want to get us out of the publisher platform dichotomy in a little bit, but let me just read this to you. So here's what it did first. It declared that, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So what does this mean in plain English? My comments on Twitter or Google or Yelp, those are my comments. Those are my comments. So by putting that speech online, it does not become Yelp speech or Google speech or Twitter speech. So this is where them merely providing the place for me to speak, my Facebook page, does not mean that they're publisher of my speech for liability purposes. But then it did something else. So then it goes further, and it says that an internet provider can, quote, restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable without being held liable for user content. Now, this is really key. This is where Section 230 gives Google and Twitter and Yelp the ability to moderate the content I put forward. So anyone who tells you Section 230 was intended for neutrality, that's not what the language says. It specifically empowers moderation. It specifically empowers a company to put its thumb on the scales to shape the kind of speech that is available on its platform. That was the purpose. That's the purpose. So now, what does this mean? It essentially means that online speech is suddenly treated a lot like offline speech. Think of the analogies that I just used. By putting speech up and complying with the rules set by the provider, it doesn't turn my speech into the provider's speech. It's kind of common sense. Now, what this has meant in practice is it was the rocket fuel for free speech online. It was the rocket fuel. All of a sudden, companies could create forums for speech without them turning into open sewers. And it could create all kinds of different sorts of forums for speech with different kinds of moderation rules that attracted different kinds of clientele and different kinds of users. And so, for example, you could have a Facebook or an Instagram that absolutely bans nudity and and porn, or you could have message boards and internet platforms that freely allowed the spread of nudity and porn. You had different rules and regulations regarding all kinds of ways in which we communicate. And moreover, I want you to, if you have this publisher or platform distinction in your mind, for a minute there, I want you to get that out of your head. Okay, I want you to get that out of your head, because many publishers are also platforms and many platforms are also publishers. The distinction depends on what you're doing at a particular point on the site. Let's say, for example, I work at the Dispatch. I write a newsletter for the Dispatch. I have a comment section. That comment section where people put comments on that we do not review beforehand, that comment section is covered by Section 230. So that if somebody says something in that comment section that is libelous, we're not responsible for it, but we do moderate it. We do take people down when they're indecent, when we know that they're lying, for example. We might take people, their comments down, but by taking their comments down, that doesn't turn us into a publisher in the comment section. Twitter is a platform, it's a publisher. It allows people to put stuff up on their own. It also engages in its own speech. When it describes or fact checks something, that particular fact check from Twitter is Twitter acting as a publisher. And so this is the rocket fuel of free speech online. This is how we have the internet that we have. So if we've now been engaged in more free speech right now than probably any generation of humans who's ever inhabited the planet, our ability to get our message out is just an average, normal human being is unmatched in the history of humanity. Why are we so mad? Why are we so worried about free speech? And when I say unmatched, I mean, my oldest daughter's roommate just picked up TikTok and had a TikTok go viral, and over 1 million people saw it. That's just my daughter's roommate at the freshman year roommate at the University of Tennessee. Just out of nowhere, 1 million people see a TikTok. So why are we so mad? Well, we're so mad for multiple reasons, and for reasons that are different depending on which side of the political aisle you're on. One of the realities that has emerged in American technology, in quote unquote big tech, and often tech overall, but big tech, is at the same time that big tech was being constructed and becoming phenomenally successful. Some of the most successful companies in the entire world are American tech companies. Some of the most successful companies in the history of the world are American tech companies. And while they're becoming incredibly, massively successful, and some of them garnering enormous market share in their respective markets, they're also becoming ideological monocultures. And this is going to be very important. They're becoming ideological monocultures. So that the corporate culture of Google, now there are differences. If you talk to people at Google versus Facebook, they'll be able to tell you chapter and verse on how they think the corporate culture and even the ideology of the companies is different. Facebook is not Twitter, is not Google. They're not all the same. But if you're someone on the right, you will say, well, but they're all pretty much dominated by people on the left. So you have an ideological monoculture with enormous amount of market power, an enormous amount of success. And what you begin to realize that, especially for a lot of people who've built up public voices on social media who are conservatives, is that your lines of communication to your public are in the hands of people who do not like your speech. They do not like your perspective, do not like your point of view. And so you feel an enormous sense of vulnerability, an enormous sense of vulnerability. But then at the same time, on the left, what people on the left have seen is they have seen the right be phenomenally successful on social media. And the right has been phenomenally successful on social media. If you go and you look at the top 10 articles in interactions on Facebook in any given day, it is dominated by the right, absolutely dominated by the right. I mean, there are days when Ben Shapiro himself draws more interactions than the New York Times, for example. Fox News is just a giant in social media interactions. So here you have right-wing media doing incredibly, incredibly well in this left-wing, in these companies created by a left-wing community. So then what ends up happening is you have two competing and often incompatible ideas on what's the problem with social media, what's the problem with media. On the right, it's these companies are on the left and they're way too powerful and they will censor us. And on the left, and this is an overgeneralization, but on the left, it's often, wait, these companies have an enormous amount of power and look at all the bad speech they're allowing into the public square. And if you talk to folks in the tech companies, they often feel caught in the middle. On the one hand, they have people who are telling them, you have to be censoring more or we're going to regulate you. And then from the right, you hear, you have to be censoring less or we're going to regulate you. And so what ends up happening is you have a lot of competing ideas about some sense that government has to do something because both sides have a grievance against big tech, but that something is almost diametrically opposed to each other because you see almost completely opposing senses of emergency and completely opposing definitions of the problem. In fact, even if you get some sort of sense of unity where it says it's very bad that big tech has all this power, that, for example, Google controls X% of search or Amazon controls X% of book sales. The real grievance is often when you scratch down a little deeper, still gets back to ideology. It still gets back to ideology because the real objection that conservatives have, quite honestly, to social media companies and to big tech in general isn't their bigness, it's their ideology. Because in reality, there's an awful lot of social media competition out there. There's an awful lot of places where you can reach an awful lot of people. But all of those places are by and large controlled by one side of the political spectrum. So let me skip ahead a little bit and I'll just say this. So here we are, we have a number of proposals floating around to do something about the fact that on the left, wait a minute, there's way too much speech on the right and that we don't like, that we often feel, and sometimes is actually misinformation. Let's just be honest. There's a lot of right-wing misinformation out there, an enormous amount after the election. There needs to be more done to combat misinformation, says the left. The right says there needs to be more done to combat censorship. The problem you have, especially on the right, is that the alternatives that the right has been carving out in practice do not look so great. They do not look so great. And here's where I'm going to get to Parler and Gab. One of the problems that you have on the right is that the right wants less moderation. It wants less. The problem with the less moderation call is that when that happens on the internet, the sites get bad. So if you're going to go and you're going to say, hey, we want to set up competing institutions to Facebook or competing institutions for Twitter, Parler and Gab, in particular, Parler isn't just limited because it had a deal with Amazon Web Services that it breached, a contract that it breached, which caused Amazon Web Services to cut them off. Even if they weren't with AWS, Parler was going to be inherently limited by the unpleasantness and the nastiness and the porn problem on the platform. Gab has been existed for years. It is not a place people like to be. And so the necessity of moderation for market share is there. It is absolutely there. The problem is that the right solutions will undermine the very ability to moderate that makes much of the internet palatable. Makes much of it palatable. Some of the left solutions are that their ideas, government-mandated censorship, are so broad they'd be opening Pandora's box for large-scale amounts of censorship, even beyond what more progressive politicians intend. And this is a critique that comes from free speech activists on the left as well. The real problem, the real issue is the hardest one to solve. The real issue is the hardest one to solve, and that is what we're really talking about here is you have an industry that is populated top to bottom by predominantly people on one side of the political spectrum. And that has created an enormous amount of mistrust and then an enormous amount of resentment. Mistrust from the right, often based in some of these individual instances of censorship that are very real, such as when Amazon took Ryan Anderson's book about transgender issues off the shelves, creates an enormous amount of mistrust. And then on the left, the notion that these industries are populated by people, allies, so to speak, but who are then enabling and permitting and allowing an enormous amount of speech that is directly contrary to progressive ideas is a source of a huge amount of resentment and anger. And so that's what we're waiting in, is this incredibly, incredibly difficult problem to solve that is in many ways rooted in this reality of ideological monopoly. And one last thing about monopolies. A lot of people are looking at what is really an ideological issue through the lens of antitrust. And antitrust is not a free speech doctrine. It is not. And if you're on the right and you're thinking that the solution to what's happening on social media rests in antitrust, I think you're going to be disappointed. Number one, the doctrines aren't going to be as easy to apply as you think they are. Number two, even if you're able to succeed, you're still not dealing with the underlying ideological monopoly issue. Let's say you break off Instagram from Facebook. You have progressive Facebook and progressive Instagram. We have lots of social media competition, but it's almost all of these corporations are largely in progressive hands. So the issue is, from the right, isn't as much the bigness. It's the ideological monopoly, and that's a very difficult thing to solve. In fact, it's hard to think of a way to solve that respects constitutional rights. But I think what we have to drill down to is we have to acknowledge, however, at the bottom line, with all of this, we are still in a position right now in the United States of America, where not only legally First Amendment doctrine is very robust and strong, but also practically, we have more access to reach more people with our ideas than in any time in human history. It's just a fact. And if you're concerned about free speech, you should think long and hard before you grant to the most powerful entity, or you're concerned about bigness, or you're concerned about power. You should think long and hard before you grant to the biggest and most powerful entity of all, the United States government, the power to intervene into a free speech marketplace that is more free and more accessible than any time in human history, and start to make that less free and less accessible, and to give them more power to make it less free and less accessible. And one last thing, and we'll answer questions. We need to be very careful that we don't let micro issues distract us from macro truth. There are micro issues such as certain specific individuals who have had issues with things as diverse as ads or book sales but there's still a macro truth that conservatives still have an enormous platform that they have used very successfully to reach their fellow Americans. And so if you focus on the micro and you use the existence of these real issues that are in the individual level to change legal regimes that could blow back at you on the macro level, that's fundamentally self-defeating. All right, let's answer some questions.
Great. Thanks, David. Thanks for the overview. We have some questions rolling in, and feel free to keep sending those along here. We'll gather those. You touched on, I'm going to kick it off with my own question, which is you touched on some competing reform proposals emerging in Washington. There's at least, several emerging. I think notable ones led by Senator Klobuchar and another by Senator John Thune. And I'm just curious, you're handicapping Washington this year when you have a new administration. Both the former administration and the new administration have indicated desire to reform Section 230, as I've seen in the news. But given the makeup of Congress, and I think the fact that there's been a lot of donors from big tech companies to Biden, Vice President Harris is from Silicon Valley area, San Francisco Bay Area. I don't know what her base of support is from big tech. What are your thoughts on the timing and likelihood of reform?
I don't think big reform is in the offing, in part because both sides have such incompatible goals, and where they do overlap, there are some small areas of overlap. It tends to be small ball. But where they have the big goals, such as folks on the left who want to see social media companies be far more proactive with misinformation, even to the extent sometimes of arguing that some of the misinformation can constitute some kind of civil rights violation, or what is often called, sometimes correctly, sometimes incorrectly, is misinformation can be a civil rights violation. So the big reforms on the left, they just don't have the numbers for that. And of course, there's no way any big reform from the right is going to come through. There's just no way that anything that would make the Democratic House and Senate and Democratic administration say, "Oh, you mean more stop the steal speech online? That's what we're gonna protect that more?" No, that's a no-go. Now, that's not to say that you might not have some reforms around much narrower issues like cyber stalking, for example, or certain kinds of, cyberbullying, that you might have some sort of much more small ball reforms, but those are not the reforms that, for example, light Twitter on fire. Oh, you're muted.
Thanks. I'm sure the panel will pick up on that, some of those prognostications of reform as well. We got a question from the audience, David. Someone writes, what are your thoughts on the idea that anonymity empowers people to do unpleasant things on less regulated sites? Would ending anonymity online help solve the problem?
Well, you've got a real problem. So one thing that I didn't get into as much is we're not talking about Section 230 in a vacuum. In fact, there's a pretty strong argument that the core protections of Section 230, not in all of the details and all of the particulars, but some of the core of Section 230 would be constitutionally mandated anyway, that under existing constitutional First Amendment doctrines, the extent to which the state can hold, say, the dispatch liable, or it can regulate in such a precise way, the way in which the dispatch moderates its comments, or the way in which the mission and the way in which these companies create their moderation guidelines. You've got a lot of First Amendment issues there. You really have a lot of serious First Amendment issues there. So each of these companies, every company has its own First Amendment rights. And so the ability of the government to say, here's the way your platform should be used for speech, there's some real limits there. And you raise one here that I think is very problematic. And that is, so if I was creating my own social media platform, there's a strong argument for real names. Facebook, you use real names. There's a strong argument for real names. But there's not as strong an argument for the government to mandate anonymity. And in fact, anonymous speech has a long history in the United States of being indispensable to some of our most important social movements. So protections for anonymous speech are deeply embedded in First Amendment doctrine, and rightfully so. So me as a private citizen, I might be able to create a company that says, my platform, I want real names because I think it'll be a healthier place. I can do that. I would have the freedom to do that. If the government then came in and said, nope, everyone on your platform has to, or if I wanted to do one that had anonymity and the government came in and said, nope, everyone has to have their names known, that's a constitutional issue. And the one thing that I would say is, I agree to an extent that anonymity can empower some misconduct and toxic speech, but I also know that Facebook is no free speech nirvana. It's not like the comments on Facebook on my articles are any different from the comments on, so if it's Jane Smith on Facebook, her comment is just as toxic on Facebook than it is when she's operating under, deplorable from Florida 973. The comments are basically the same. I think that one of the arguments of anonymity against anonymity being sort of a cure for what ails us in a lot of ways is in fact, the sites that require real names, they can turn into Chernobyl real quick.
Great. Another listener has a question here and says, could David address the other concern that Dr. Marianne Franks will likely address, and that's the regulation of speech that is damaging, bordering on threatening on social media. I think the example here is suing because plaintiffs claim injury due to, for example, revenge porn. That type of harm doesn't fit into the left-right paradigm.
Yeah. And that's some of the areas where you might see some agreement. Now, a lot of you might see some right-left agreement on, but the question is going to be under what circumstances and what ability, before we start talking about increased state regulation, one of the things that we need to talk about is corporate capability, not just corporate culpability. And so if you're talking about, in particular, a lot of small and startup sites, the ability to pre-screen everything that goes up, or the ability to have automatic processes in place that can take down offending content instantaneously is limited. For example, if you're talking about porn, a lot of major social media platforms already prohibit porn. So porn is already not permitted on the platform, yet it often finds its way up there anyway. But yeah, I think when you're talking about things like revenge porn, things like cyber stalking, things where you have private citizens, not public figures, but private citizens who are subject to intentional harassing attack, then I think there is room for creative legislative solutions. And why I say that is because, and now remember, a lot of this you're going to find we need to stop thinking of the online world as so totally different from everything that we can't have offline analogies. Just as I used offline analogies to describe why Section 230 makes intuitive sense, there's an offline analogy as to why regulating harassment online makes sense. And those are anti-harassment statutes like Title VII, for example, which prohibit hostile environment harassment in a workplace, which prohibit quid pro quo harassment in a workplace. So in a and they do so constitutionally. It is hostile environment harassment is not deemed to be a violation. True hostile environment harassment, prohibiting that does not violate the First Amendment. And so is there an analog to a hostile environment harassment type claim that is technologically feasible and that wouldn't have strong negative knock-on effects for free speech more broadly, or inhibit smaller companies' ability to grow and develop? Those are conversations worth having. They're also not the conversations that are driving all of the vitriol politically. But yeah, those are absolutely conversations worth having.
Great. We'll probably hopefully keep having that in the second part of our program here. there's another question here that I think is also a good one from a listener. What's done in other countries or in the EU on this issue, and can we learn anything from them when it comes to regulating the internet?
Well, it's very difficult to compare the EU to the US because we're talking about entities that do not have the same kinds of constitutional protections for free speech that we have here. And so the ability of the state to step in, or government entities to step in and to mandate that corporations engage in certain kinds of behavior regarding speech, it's much greater than it is here. And one of my concerns is I don't want us to take a problem that we perceive, and often misperceive, to be honest, often misperceive, and do something that's going to undermine fundamental First Amendment protections. And that's one of the reasons why I'm very wary of casting an eye to the EU. I'm very wary of casting an eye to some of these other nations, because we're talking about nations that have radically different doctrines of free speech. And, often when you drill down, I keep coming back to this ideological political point, that when you really drill down to so much of the toxic in the nature of the anger here is rooted in a sense of partisan advantage or disadvantage. That's what it's really rooted in. The left feels like big tech has granted the right and inappropriate and unearned access. And the right believes that the big tech is engaging in inappropriate and in tyrannical censorship. And this is almost an area where the danger, government intervening into a dispute about ideological speech, is a red flashing danger zone for our fundamental First Amendment doctrine. And so that's why I'm very leery of comparisons with the EU, because we don't want to, throw out the First Amendment baby with the social media bathwater.
I believe it was Chancellor Angela Merkel who criticized Twitter or other platforms for deplatforming President Trump. We haven't talked about that yet. I mean, if there's any greater,
a world leader would sort of be a little sobered about that.
Yeah, well, in to me that the Trump deplatforming is one of the greatest indications why this topic is important right now. And I'm curious your take. Maybe you've tweeted about it or written about it.
I've written about it. Yeah.
Do you think the platforms should allow him back? Was it the right thing to do to kick him off?
I think it was the right thing to do to kick him off for a couple of reasons. One, I don't think anyone should, if I join a platform, there are rules. And I believe we should that those rules should apply equally. And I do not believe that there's a presidential privilege exempting you for the rules. I think that's I just hate the very note on all levels of whether it's criminal justice system, political accountability, compliance with terms of service. I hate the idea of presidential or governmental privileges. Hate it. It is inimical to our Republican system of government, I think. And so Trump we have to be honest, he was skating on presidential privilege for months and years. If it'd been me tweeting some of the exact same things that he had tweeted, I would have been gone from Twitter a long time ago. So come on the platform, Trump, comply with the rules. Number two, there's an interesting, I had a really interesting conversation with some folks in tech world about social media and free speech rules. And my position has long been, I want companies to voluntarily adopt rules that are biased towards viewpoint neutrality. In other words, if you're going create a version of sort of the First Amendment viewpoint neutrality doctrine. Can't do it perfectly because some of the, I don't want these platforms hosting porn, for example. But a version of it that says, here's what we're going to do. We're going to, our rules as much as possible, while we're going to regulate harassment, we're going to regulate bullying, we're going to regulate pornography, but we're not going to do it with our ideological thumb on the scales. So there should be some baseline level of viewpoint neutrality in your rules. And I was asked this question, well, what happens if our platform we know our platform is being used to foment violence on the ground. And my answer to that was really fast. Well, then I think you cut it off, because the difference between a Facebook and the government is this. The government can do two things at once. It can protect speech and it can maintain order. So it can say, we're going to allow someone to engage in provocative speech, but we're also going to have cops there to maintain order. Facebook provides a platform for speech, or Twitter provides a platform for speech, but it can't maintain order. And so if it's seeing its platform being used to foment violence, I don't see a problem at all of pulling the plug. And when I was giving that, when I was making that analysis, and we were explicitly talking about the ways in which social media has been used to foment riots and violence in the developing world, I didn't think about my own country. This was more than a year ago, but we had seen the Capitol just taken over, and the use of social media to enhance, to foment, to plan, to execute a violent insurrection in the United States of America. And it's entirely appropriate for these private companies to pull the plug. And I also think there's something kind of, you know, the idea that the most powerful man in the world does not control an American company is a virtue. I think that's a virtue. Now, I can disagree with the way a company will exercise that authority that has and exercise its liberty. But the idea, in my view, that an American company does not have to platform the United States of America, there's something very American about that, I think.
That leads us to another set of questions, and maybe the last set from the audience that I saw come in. And this was earlier in the talk, so I think you
Sure.
partly answered this, but they were asking, why do you think social media platforms are starting to censor more in 2021? And is Twitter's new system of censorship just? I guess getting to your point about them, whether they're able to enforce. And now, do you agree with the listener that they are trying to enforce more now?
I mean, I think there's some anecdotal evidence of that. And I think, you know, it's harder to advertise, you know, to engage in political advertisement, for example. Look, I think part of the issue is the post-election period and the viral spread of really damaging lies about the election. And the ultimate result of that, which happened on January 6th, was shocking to a lot of people. And they don't want that to happen again. And you know, I think that if you're going to be arguing to a private corporation, again, you're talking about a private corporation made up of you know, not all of its employees are Americans, but most of its employees are Americans who have a particular idea, of how they want to see the company that they have worked long hours to create, to see how it is used and what effect it has on society. If you're going to tell them, you need more of me, stop persecuting me, there should be a commensurate responsibility on you to be a responsible actor. And we keep missing that in this debate. What we forget that with rights come responsibilities. And if I'm going to demand to social media, to this company that I did not create and I do not pay to use, I've never paid Twitter a dime in my life to tweet. I've never paid Facebook a dime in my life to post. If I'm going to say to these companies, you must host me, and then to say, and then what am I going to do with that? Well, what I'm going to do with that is spread a viral lie that led to the sack of the Capitol. You're not making a good case there. You're not making a good case. And so that's one of the issues that we have, is that, and you also see this with Parler and Gab. These are people who've been
Seems like we're frozen for a moment here. I did. Looks like the
Got
internet
censored by
cut.
Zoom.
Yeah.
But
I see.
anyway, so I think we on the right need to think about rights and responsibilities and we just don't, and that undermines the case for our rights.
Yeah. I see a bunch of questions and some fun ones that I think we should ask just rolled in. So I wanted to ask some of these. Thoughts about Clubhouse?
That's funny. I intend to try it. I logged in, created an account, logged in. I got so many immediate invitations to join various clubhouses. I just logged off immediately. I thought I don't have the bandwidth, but I'm going to try Clubhouse. It's a cool idea. It is. And the more sort of the more entrance into this market, the better.
Great. Yeah. The same person asks about thoughts on social media being used for discriminatory practices.
We'd have to define what is meant by that specifically.
Right.
If you're talking about using social media to advocate for various kinds of discrimination, boy, I mean, what you're talking about, let's just say, for example, debates for or against the Equality Act, which just passed the House. I mean, social media should be widely, in my view, should be widely available for people to argue for or against the Equality Act. If you say, well, I don't want my platform used for discrimination, that's often like a slippery slope, that I don't want my platform used to contradict arguments that I prefer for expansive non-discrimination laws. So again, you're getting into a lot that the devil is in the details of a lot of these very well-intentioned reforms, because as censors have found for a long time, it is very hard to create a free speech utopia. If you're going to have free speech, you're always going to have a degree of speech that you don't like. So one of the things that, when we're arguing for free speech with companies, I think we should argue for a default position of free speech. We should endeavor to exercise that free speech responsibly. But at the same time, we can also never say that there will be a free speech utopia. And then there are still red lines that we can't cross, like sacking the Capitol. This is complicated. It's not easy. And anyone's going to sail in and tell you, I have the exact way to make social media all of the things that you like and none of the things that you don't like. That's never going to happen.
Two questions more, one kind of serious and one fun one. This looks like it's from one of my colleagues at King's. He writes, could you please ask David to comment on this? The law can prohibit outright lies if they are libelous, but should the law try to prohibit other outright lies? For example, someone who lies about receiving military honors. This was a Supreme Court case, United States v. Alvarez.
Yeah. Now that's really interesting, because the Supreme Court has never held that lies are unprotected speech. That's a dangerous road again. What's a lie? What versus what's hyperbole? World's greatest cup of coffee, to quote the movie Elf. Is that a lie? Probably. if I say that I've made the world's greatest cup of coffee. Now it's easy. There are some lies that are easy to define. I received the Medal of Honor. No, I did not. That's an example of an easy lie to define. But one of the reasons why that the First Amendment has never been held to outright prohibit lying is because, as with many, for example, such as hate speech, the First Amendment does not prohibit hate speech. That creates there are real definitional problems there. And so what we've done instead is we will prohibit lies that harm specific individuals or entities. That's defamation law. That's libel law. And I feel like that's still the best response. And I guarantee you, if now a private company like a Facebook or a Twitter could say, we want to prohibit lies, period, they'll find that every bit as hard to do as a government censor would find it hard to do. And they'll be all over the place for that, with that. And they will prohibit some things that are lies and some things that are not lies. I mean, they will prohibit some lies and not other lies. And it's a mess. And you've already seen it, the mess that's created. Doesn't mean they can't try to do it right, but it always devolves into a mess.
Last question. What in your opinion would be easier to accomplish? Resolution of the Section 230 issue or peace in the Middle East?
That's a great question. Well, you know what? That question is actually that's a super insightful question. And it might be, in an interesting way, one of the most insightful questions of the night, because the resolution of the social media issue is rooted in our culture war conflict. The origin and the nature of the social media issue is rooted in our culture war conflict. Resolution of the existence of Palestine as an independent country or occupied territory is rooted in long conflict. So these are two issues that are rooted in deep conflict, and it's going to be impossible, in my view, the real issue that's really fires people up. It's going to be impossible to resolve that real issue that really riles people up without dealing with the underlying cultural clash. And what's happening on Facebook and Twitter and everywhere is a symptom of the underlying cultural disease of hyperpolarization and partisanship. And so that's why I say that all of these reform ideas, they're usually in service of one side or the other side. And therefore they're often directly defiant of the First Amendment. And that's one of the reasons why the solution is so elusive. What we're seeking is the use of social media to defeat and dominate, as opposed to the use of social media to accommodate and communicate. And you have different ways in which the right and left adopt to that view. So I think that that's a really good question, but the answer is maybe they're both equally challenging.
Great. Well, with that, I want to thank you, David, and all the listeners and the questions. So we're going to end part one and just take a 1 minute short break as we get the panelists and make sure everybody's ready to continue the discussion.